Mr. Lehrmann had sexual intercourse with Ms. Higgins and yet ran a primary case premised upon the fanciful and knowingly false premise that in the early hours of 23 March 2019 he was preoccupied with noting up details as to French submarine contracts.
This is Justice Michael Lee delivering what he says he hopes are some of his final words on the matter that has gripped Australia over 4 years. The claim that Bruce Lehrmann raped Brittany Higgins on a sofa in Federal Parliament House.
As I said, Mr. Lehrmann defended the criminal charge on a false basis, lied to police and then allowed that lie to go uncorrected before the jury. He wrongly instructed his senior counsel to cross-examine a complainant of sexual assault in 2 legal proceedings, including relevantly for present purposes in this case, on a knowingly false premise. Indeed, this was misconduct in the running of the case of such a character that even if I had not reached the level of satisfaction that Mr. Lehrmann raped Ms. Higgins and Mr. Lehrmann was therefore entitled to judgment of $20,000, in the counterfactual explained in the judgment, I would have declined to award costs in Mr. Lehrmann's favour. This would have been the appropriate exercise of discretion in circumstances given Mr. Lehrmann had acted in serious breach of his obligations under Part 5B of the Federal Court of Australia Act in advancing a case he knew was false and which occasioned much delay, inefficiency and increased cost.
The judge has already found on the balance of probabilities that Lehrmann did rape Higgins. Lehrmann's indicated he may appeal. But now he's facing an immense legal bill because the federal court judge has ordered him to hand Network 10 and its journalist Lisa Wilkinson what's likely to be millions of dollars to pay their lawyers. Lehrmann's own lawyers up till now have been working on a no-win, no-fee basis and won't get paid because they lost. The lawyers earlier this week told the court Lehrmann does not have a secret financial backer out there paying his bills. He likely does not have millions of dollars lying around. This decision may bankrupt him, and given he now has new lawyers who may not be working no-win, no-fee, it could make an appeal less likely.
There are no real winners in this litigation.
Something that's been grinding Michael Lee's gears about the epic legal storm surrounding Lehrmann and Higgins is the way, he says, everyone only hears what they want to hear.
With the predictability of an atomic clock, partisans have focused solely on those parts of the judgment that happen to align with preconceived notions. But the reality of mixed findings has been somewhat obscured in the public statements of the respondents and their submissions as to costs, which advance an assertion that they won the litigation and that costs should axiomatically follow the event.
Here's what he means. 10 won the case, yes, but it wasn't a total win, and they shouldn't assume they get to force Bruce Lehrmann to pay all their legal costs. Bruce Lehrmann sued Network 10 and presenter Lisa Wilkinson over the bombshell 2021 story on The Project, in which Brittany Higgins told her emotional story of being raped by Bruce Lehrmann and then despairing as she claimed, her bosses failed to act.
And so I would try and raise it and I would try and bring it up, and it always sort of came back to sort of being a me issue, and if you can't deal with it, then you can leave.
Lehrmann said he never had sex of any kind with Higgins, and that when the pair came back to Parliament House one autumn night in 2019 after a big night of drinking, he went to his desk and made some notes about French submarine contracts.
Oh, hi mate. Bruce Lehrmann here with Minister Linda Reynolds. We've been requested to pick up some documents. I've forgotten my pass.
Ten and Wilkinson had 2 defences. First, that Brittany Higgins' claim of being raped was true, and second, that their story was covered by statutory qualified privilege. That's a rule designed to protect well-intentioned, careful journalism. The qualified privilege defence means a publisher has to prove that they made all reasonable efforts to ensure the publication was true. In his judgment back in April, Justice Lee found Ten and Wilkinson had successfully proven the truth of the rape on the balance of probabilities, which is the standard in civil cases like this. But he said 10 had failed on the qualified privilege defence.
First, I explained why the conduct of both Network 10 and Ms Wilkinson in publishing the project program, in its character of defying the defamatory imputations as to Mr Lehrmann, was unreasonable. Contrary to the assertions of Network 10, the examination of the respondent's conduct was not devoid of nor divorced from reality, nor did it involve picking apart and dissecting the respondent's conduct by reference to a standard of perfection. For anyone taking the trouble to read the judgment would conclude that I did not consider the evaluative assessment required by the statutory qualified privilege defence to be a close-run thing.
That there is a big swipe at Network 10 over something else that has made the judge very cranky. The statements made on the court steps and in media interviews after the trial by a representative of 10's law firm.
In terms of Channel 10's reasonableness, look, the way in which judges and barristers, and this is the problem with defamation law in Australia, the way in which judges and barristers pick apart and dissect what journalists did or didn't do in applying a legal threshold or legal test of reasonableness is quite often divorced from reality.
The judge went on.
I also explained that although the respondents legally justified their imputation of rape, their conduct was not justifiable in any broader sense. The material in evidence is replete with the recognition by the project team that the major theme of the broadcast was the publication of what Mr. Shiraz, the promoter of the project, and the regular conduit between Ms. Higgins and Mr. Llewellyn had pitched to Ms. Wilkinson. The credulous approach taken as to the allegations pitched by Mr. Shiraz and as to Ms. Higgins' credit generally lacked both rigour and objectivity. Contrary to the recent assertions of Network 10, a publication is not reasonable simply because it turns out to be true in some respects.
Mr. Shiraz, that's Brittany Higgins' fiancé. He pitched the story to Lisa Wilkinson by email under the heading Liberal Party Me Too Project Pitch. Shiraz told Wilkinson it was a story of a young rape victim being silenced by Scott Morrison's federal government. That's something the judge said was not borne out by the facts. He found that, in fact, Minister Linda Reynolds and her Chief of Staff Fiona Brown had not tried to cover up the rape or pressure Higgins into silence. 10 tried to argue in its submissions that it wasn't claiming there was a cover-up, just that Brittany Higgins said so. Here's what the judge said about that, and it relates to the way he says 10 and its supporters have crowed about their victory.
The result is best characterised as the respondents overcoming a misconceived claim in relation to a broadcast because they were able to prove at trial the substantial truth of what the contemporaneous material demonstrates that they considered to be the less substantial allegation made in the broadcast.
In other words, the judge says 10's chosen to ignore the fact they did present this as a cover-up and that just wasn't true. The judge said even though 10 and Wilkinson's barristers had made very learned submissions, there was no hiding the fact that Lisa Wilkinson and producer Angus Llewellyn wholly believed Brittany Higgins' story and didn't do enough to establish whether it was true.
This is a case where extensive contemporaneous records demonstrates a very large gulf between the carefully drafted respondents' affidavits and the true position as to the immediate and unquestioning belief in Ms. Higgins' account by Mr. Llewellyn and Ms. Wilkinson, and as to the project team's lack of interest in examining the account properly or obtaining contrary accounts.
The reason the judge is going through this is that Lehrmann's lawyers sought to argue that because 10 lost on the qualified privilege defence, Lehrmann should not have to pay 10's legal bills for preparing and running that defence. Ultimately, the judge didn't agree with that argument. He said the two defences were bound up together, even if he had serious problems with 10's journalism.
One cannot ignore the fact that the relevant conduct of Network 10 relating to the publication of the project program was far from reasonable, and the statutory qualified privilege case, while not hopeless, was weak.
The judge's other big problem with Network 10's behaviour was about the Logie speech made in 2022, in which Lisa Wilkinson declared,
"After 40 years in journalism, this interview and this story is by far the most important work I have ever done. And I knew it from the very first phone call I had early last year with a young woman whose name, she told me, was Brittany Higgins."
That was 8 days before Bruce Lehrmann was supposed to face the ACT Supreme Court in a criminal trial for rape, at which Wilkinson was supposed to be a witness. A furious ACT judge delayed the trial because of the speech. Ultimately, the trial was aborted without any finding of guilt against Lehrmann. The judge said the Logie speech was grossly improper, and he's slated 10 for approving it and continuing to defend it in this defamation trial. And this brought him back to the lawyer's statement on the court steps and subsequent interviews where he defended Ten's journalism.
Following the delivery of judgment, however, a solicitor spokesman retained on behalf of Network 10 made what might be described as a victory tour and expressed public comments relevant to the relevant findings and repeatedly expressed the view the Logie speech not only did not have the tendency to interfere with the administration of justice, but presented no difficulty whatsoever.
If you've been listening to The Front, you'll know the judge demanded an explanation from Ten. He wanted to know if Ten thought the Logie speech was still a good idea, despite the fact he'd slammed it in his judgment. This was high-stakes stuff for Ten. The risk was that if the judge was sufficiently annoyed, he could throw out Ten's cost claim altogether, and it'd be left footing its own bill. Ten and its lawyers humbly asked the judge for forgiveness, saying their remarks were off the cuff and unintentional, and that Ten takes its legal obligations very seriously.
After these issues were raised, further affidavits and submissions explaining the considered and current view of Network 10 were provided to the court. This material suggests that Soul of Tarsus-like, the scales have belatedly fallen from the anthropomorphic eyes of Network 10. In the circumstances, no further comment or action from this court is necessary or appropriate.
So he's given them a scare and we'll leave it there. Saul of Tarsus, by the way, is also known as Paul the Apostle. He was cured of blindness in the Bible when scales like that of a fish fell from his eyes and he could suddenly see everything clearly. Coming up, what the judge said about Brittany Higgins' demand Lisa Wilkinson sack her lawyer. The best coverage of this and all the big trials is at theaustralian.com.au, where our subscribers are always first to know. On Monday, the appeal of Christopher Michael Dawson of The Teacher's Pet kicks off, and we'll have live blogs and all the news as it happens. Join our subscribers now by going to theaustralian.com.au, and we'll be back after this break. One of the sideshows that occupied Michael Lee's time during this trial was a costs dispute between Lisa Wilkinson and her employers, Network 10. That's still raging, by the way, and it will be determined by an independent referee who'll decide how much everyone's bills are and who pays what later this month. But it's thanks to that cross-claim that the court heard a large amount of evidence about what was going on within Network 10 as its relationship with its star, Lisa Wilkinson, deteriorated. The Logie speech cost Wilkinson her role on the project. In November 2022, she made an emotional exit, positioning it as her decision rather than Ten's.
I have had a ball, but for me, right now, it's time for a change. To be clear, I'm not leaving 10, and we're looking at some very exciting work ideas ahead. But I also have to be honest with you. The last 6 months have not been easy, and the relentless, targeted toxicity by some sections of the media has taken a toll, not just on me, but on people I love.
Hiring Wilkinson had been a major coup for Ten back in 2017. That's because Wilkinson, the popular long-term co-host of rival Network 9's Today breakfast program, had quit Nine on a point of principle. She wasn't earning as much as her male co-host, Carl Stefanovic. Wilkinson then brought in the Higgins story. It had been broken earlier that day by Samantha Maiden of news.com.au, but the project had Higgins on camera. It was a ratings success that turned into a social juggernaut as Higgins' story captivated Australians angry about violence against women.
We are all here today, not because we want to be here, but because we have to be here. We fundamentally recognise the system is broken. We are here because it's unfathomable that we are still having to fight this same stale, tired fight.
But the Logie speech, which should have been a jewel in Ten's crown, was tarnished when the ACT judge reacted with such fury and delayed the trial. Wilkinson has not returned to an on-air role, even though she's still employed by Ten. Documents tendered to court show Wilkinson felt abandoned and betrayed by Ten. She insisted Ten and its lawyers had approved the speech and even asked her to make it as a deliberate show of support for Brittany Higgins. Wilkinson was right, and part of Ten's humiliation in this trial was that its treatment of Wilkinson was laid bare. When Bruce Lehrmann first indicated he was suing, Lisa Wilkinson hired her own solicitors and barrister, prominent senior counsel Sue Chrysanthou, and that turned into another dispute with Ten. Buried in all the documents that surfaced in the cross-claim, but found by Justice Lee, was an unusual request from Brittany Higgins' solicitor Leon Zweier well before this trial kicked off.
It is important for your clients to appreciate that Brittany is doing so on the basis that your clients will not offer Lehrmann a payment of damages, or a retraction of the defamatory statements, or an apology or costs, or any other relief, to settle the civil claims commenced by Lehrmann against your clients. For the avoidance of any misunderstandings, Brittany has instructed me not to assist lawyers and counsel currently retained by Lisa Wilkinson to defend civil claims commenced by Lehrmann against Lisa Wilkinson. I am not prepared to work with Lisa's current senior counsel under any circumstances.
There's a complicated backstory. Chrysanthou had acted for Brittany Higgins in the past, briefly, but some of her other prominent cases had included acting for Jeffrey Rush, the actor who successfully sued for defamation over sexual harassment claims, and former Attorney General Christian Porter, who also faced unproven claims of sexual misconduct. But there's a rule barristers have to act for any client that asks, unless they've got a conflict of interest or are already engaged. So the judge came in strongly on the side of Chrysanthou. He noted that after Leon Zweier's email, Ten did make Lehrmann an offer to settle, but it didn't include any damages or apology, just as Higgins had requested. The judge also noted that Ten's boss, Beverly McGarvey, had repeatedly tried to get Lisa Wilkinson to drop Sue Chrysanthou, and the solicitors Leon Zweier had objected to. Ten denied that acted on the demands in Leon Zweier's letter. The judge found that curious.
By reason of the fact that Ms McGarvey, on behalf of Network 10, at least twice explicitly referred to the conditions as a reason why Ms Wilkinson should replace her chosen senior counsel, it appeared to me available to infer that what might be thought to be the appropriate response to Ms Higgins' solicitor was not conveyed. That would have been to say, with respect, that if Ms Higgins did not wish to cooperate with Network 10 without imposing conditions upon representation of a party and potential settlement options, then Ms Higgins will need to be subpoenaed and she'll be obliged to assist a court of justice in coming along to tell the truth until excused.
Ultimately, the judge said he accepted the reassurances of Ten's counsel, Matt Collins KC, that Ten had not felt itself bound by the Zweier letter. So here's what the judge ruled on costs. Ten and Wilkinson can recover costs from Lehrmann on an indemnity basis. That means the vast majority of the bill. But that only applies to the truth defence, which they won. On the other defence, qualified privilege, which they lost, Ten and Wilkinson can recover costs on an ordinary or party-to-party basis, which means about 70% of its costs. There are a couple of exceptions, but it's the best result Ten and Wilkinson could have hoped for. The matter comes back to court on May 27, when the judge will decide the terms of reference for the referee, who'll sort out exactly how big the bills are and who pays what. And then it was over, but for one last Michael Lee mic drop.
I publish my reasons. Call the next matter.
If you're missing Justice Lee already, don't worry. He'll be back in another big court case soon, and we'll be covering it for our subscribers. This week, there's the federal budget and Chris Dawson's appeal to keep us busy. Join our subscribers at theaustralian.com.au and help us make Australia's best journalism. The Front is made by Kristen Amiot, Joshua Burton, Tiffany Dimmack, Leah Samaglu, Jasper Leake, Matthew Condon and me, Claire Harvey.